del speaker.
Muchas gracias, Fernando. Entre otros aspectos interesantes de tu presentación, creo que un tema importante ahí es pensar la reflexión sobre la influencia de la opinión pública y de los medios de comunicación en la independencia del Poder Judicial, ¿verdad? Porque a menudo uno piensa más en el Poder Ejecutivo, sobre todo, a veces en el Poder Legislativo, pero es interesante ver cuando un juez tiene toda la opinión pública de un país encima, una buena parte de la opinión pública, cómo eso puede afectar su capacidad de decidir únicamente y exclusivamente en base a los hechos y en base al derecho, pese a toda esa presión, digamos. Next, we'll have Peter Kahn. Peter is an attorney with Williams and Connolly, and I understand that he specializes in arbitration, among other areas, and he will share with us his comments, including some in relation to cases that he has managed dealing with some of the Latin American countries. Thank you. Welcome.
Thank you. Good afternoon, and I add my thanks to the organization for their kind invitation to join you today, and certainly to my distinguished co-panelists. My task is to follow up on the excellent talks this morning by former President Hurtado and Jorge Zavala from Ecuador on the state of affairs there, and to give you a concrete example of the political control of the judiciary there and how we have dealt with it here in the United States. My law firm, as Ignacio said, is Williams & Connolly. We're based here in Washington. And my practice is international litigation, more so than straight arbitration. And I've had the privilege of representing, in my 37 years of practice, people who have been involved in these types of cases all over the world, but lately it seems that Latin America is hot. And I think we all know why, based on what we've heard earlier today. We have been representing the Isaias family, and this is the case I want to discuss with you briefly today, over the past decade, in fact, 12 years to be exact, and it has been a case study of political use, or should I really say misuse, of the judicial system by Ecuador to go after individuals who are considered political and or economic enemies of the state. Now, it's been our job to bring this matter to light with the United States Department of State and the United States Department of Justice as we fought the extradition requests by the government of Ecuador to send the Isaias family back there to stand trial in what undoubtedly would be a kangaroo court. We have thus far been successful in beating back each of the several requests for extradition by focusing carefully with the United States government on the specifics of the legal argument that there is a lack of evidence of an extraditable offense, rather than focusing on the political misdeeds of the government of Ecuador. But of course, they couldn't help but color our arguments, and we have used them extensively. But lest you think the United States is going to be concerned in an extradition case with the political aspects, I must tell you that's a hard argument to make, because as you well know, the treaties between our countries, and extradition in particular, do not make room for that, lest it be a political crime. And in most cases, they're not necessarily political crimes. They're just not crimes at all. But that's what we have to deal with. Now, there's not enough time to cover the 12 years of warfare that we've waged, but I'll try to give justice in the brief time that I have. And I need to first give you a little bit of background. In 1960, the Isaias family acquired an interest in a bank in Ecuador called Filan Banco. And by the late 1990s, Filan Banco had become the second largest bank in Ecuador. Roberto and William Isaias were prominent and successful businessmen and public figures in Ecuador. Aside from Filan Banco, they owned several major Ecuadorian media outlets, which will come into play later, and many other corporations and businesses. In 1998, a financial crisis hit Ecuador, together with most of the rest of Latin America and parts of Asia as well. And in Ecuador, this crisis was triggered by three things. One, a collapse of the world oil prices. Second, El Nino. And third, internal political instability. And this crisis caused a severe strain on the Ecuadorian banking system and ultimately led to a run on Ecuadorian banks. And in 1999, Ecuador became the first country to default on its Brady bonds. Filimbanco, like all banks in Ecuador, suffered from financial crisis. And in September 1998, Filimbanco obtained liquidity loans from the government of Ecuador in an attempt to stay afloat. But on December 2nd, 1998, Filimbanco was turned over to the government, as was as I said, most banks in Ecuador. And from that day forward, Filimbanco was managed by the Ecuadorian government. But interestingly, in March of 1999, just after the bank was turned over, the Central Bank of Ecuador confirmed that the finances of Filimbanco were in proper order at the time the government of Ecuador took over. Now, of course, as I indicated to you earlier, that political instability was one of the issues of this financial crisis, so obviously the government at that time needed to blame someone, and who better to blame? You can't blame yourself, which is really the case, so you have to blame the bankers. So after the government took over, the then banking superintendent, Juan Falcone, demanded an investigation of the bank's collapse. And the prosecutor general at the time, Maria Yepes, issued an opinion finding no evidence that anyone at Filimbanco had misused any liquidity loans and concluded that there was no basis to charge the Isaias brothers, or anyone else for that matter, with peculado bancaria, bank peculation, or any other extraditable offense under our extradition treaty. And importantly, under Ecuadorian law, the chief prosecutor, Ms. Yepes, has ultimate authority and discretion over charging decisions. A defendant cannot be called to trial unless the prosecutor has found supporting evidence to charge the defendant with a crime. However, not to anyone's surprise, on March 19, 2003, then Supreme Court President Armando Bermeo, a member of the Izquierda Democracia Party, the left-wing party, who had been very much against the economic strength of the Isaias family and others in Ecuador, called them to trial for peculado bancario, interestingly, a crime that had not even come into effect until May of 1999, after they had already turned the bank over to the government, obviously an ex post facto and improper retroactivity issue. The order was clearly ultra-virus and illegal, but that didn't stop the courts and the government. The Ecuadorian Congress attempted to impeach the prosecutor, Ms. Yepes, for her report. She defended her conclusions since that time, testifying, and I'm quoting, "I will not allow myself to be used as an instrument of revenge," and she has stood by her findings ever since in the face of very trying pressure by the government of Ecuador. Now, in 2004, the government of Ecuador let me back up. Since the very beginning, since 2001, the government of Ecuador had been seeking the extradition of the Isaias brothers, and finally, and we'd been fighting it all the way, and finally in 2004, we were successful in convincing the United States Department of State and the Department of Justice not to go forward with that, and they so notified the government of Ecuador saying, you need specific allegations, you don't have any here, or you have not presented them here. And then we thought we had won, and we put our briefcases away and went on to other matters. But all of a sudden, in 2008, the case came back to life. And not surprisingly, it followed the election of Rafael Correa, who you've heard about this morning. He, in November 2006, won the presidency of Ecuador, and as evidenced in his inauguration in 2007, it was attended by the then Iranian President Mahmoud Ahmadinejad, and we were off to the races. He immediately instituted a series of political activities that put pressure on the Ecuadorian judiciary. In March 2007, for example, he had the Supreme Electoral Tribunal impeach 57 legislators who were opposed to him. Later that month, 2 of these legislators were shot trying to fight through a police cordon to resume their seats. A judge, and here's the legal aspect of it, of the judicial aspect, a judge who issued an injunction blocking the removal of these opposition lawmakers was removed from office, and that was just the beginning of the removal of the judiciary. In April 2007, after the Constitutional Tribunal reinstated 49 of the 57 lawmakers, the Correa-controlled Congress impeached all 9 members of the Constitutional Tribunal. And then in May, he took over the government took over the El Telegrafo, the large newspaper there, and he filed a criminal suit against the editors of La Hora for the publication of what he called a hostile editorial. And of course, you heard earlier this morning, he went on later to sue El Universo for the same or similar activity. In June of 2007, he demanded that the banking superintendent be imprisoned for opposing his agenda and announced his intention to have the newly formed Constituent Assembly dissolve the Congress. He then declared his intention to shut down the opposition television stations, and this goes on. And finally, in November, his Constituent Assembly declared Congress in permanent recess, declared his decisions immune from judicial challenge, and we're going to hear about this again, and decreed that any court action in opposition will result in the removal from office of the opposing judges. So this is what we and our clients faced. In a pre-dawn raid in July of 2008, the government of Ecuador forcibly seized control of 195 corporations totaling hundreds of millions of dollars in assets of the Isaias family. And then, in the face of this, the finance minister resigned rather than sign the documents purporting to authorize the raid. But most importantly, on July 9th, the Constituent Assembly approved Mandate Number 13, which, believe it or not, stated that the confiscation actions by the government are not subject to judicial review and imposed criminal sanctions on any judge daring to hear allegations in defense of the Isaias group. It just gets worse from there. In May 2009, the National Court of Justice issued an order calling the Isaias family to trial, and that judgment was then appealed. But interestingly, in January of 2010, the Supreme Court, the National Court of the Appellate Court, issued an order exonerating the Isaias brothers of any charge of peculado, and this was the sort of the last bastion of independent judiciary. Interestingly, this, as you can imagine, raised holy hell in the presidential palace. And immediately thereafter, President Correa and the Prosecutor General called for the removal of the 3 judges who authored the January 15th order. The judges were stripped of their positions, barred for life from political office, and were put on trial for breach of public duty. A new ad hoc panel of replacement judges was installed, all of whom had conflicts of interest, not the least of which was the fact that they were closely aligned with President Correa personally. And on May 16th, 11 days after the judges were installed, despite the fact that there have been hundreds of thousands of pages of court record, the judges issued an immediate order withdrawing the former opinion, saying it never existed. It's a term never ever used before in Ecuador. Let me just quickly conclude, because I see that Representative Engel is here, and I don't want to hold him up, or you as well. But the trial of the Isaias family went forward in January 2011. It was, as expected, a kangaroo court. They were not allowed to introduce any significant evidence. The government controlled the entire operation. An opinion came out in April of 2012. It was, interestingly, it was a 70-page opinion. The Isaias brothers were mentioned 3 times. Twice to name them as defendants, and the 3rd time to name them as being convicted. There was literally no substantive evidence to tie them to the alleged crimes. And the irony here is that that's what cost the government of Ecuador the extradition. We were able to demonstrate to the Department of State and the Department of Justice that there was no evidence presented, and the United States government supported that position. And this past June, we were successful again in blocking the extradition of the Isaias family. I'm happy to answer any questions after. Appreciate your time.